Good day, everyone. Welcome to Orange Tree's webinar, The Only Constant is Change, What You Should Know About Background Screening Best Practices Going into 2020. My name is Jeff Ernst. I'm the Vice President of Sales and Marketing here at Orange Tree. I'll be your host today. We're delighted that you're able to join us, and we're equally as delighted to have Scott Paler, a real expert in the business of compliance in the background screening industry. And we'll get to Scott's presentation in just a moment. I just want to handle a couple of things. One, frequently receive a question regarding the handout. The slides are available already. They are in the tool under the handout section, so feel free to download those. We will also send out an email following today's presentation with access to the slides, as well as a copy or a recording rather of the webinar. So if for some reason you have to drop a little bit early, likely you'll want to listen to it again. It'll be made available for you at that particular time this afternoon. If you do have questions throughout the course of Scott's presentation, feel free to enter those into the chat window. We will have ample opportunity following Scott's presentation to address those questions at the end of today's prepared material. So in the meantime, as we get going here, what I'd like to do is just provide an introduction for Scott. Scott is a partner and attorney at DeWitt. He serves as chair of the firm's background screening practices group. He is the past chair of the firm's employment practice group and an active member of the firm's litigation practice group. Scott has developed a niche expertise in background screening. Over his career, he has advised more than 100 background screening companies on compliance and business issues. He has also defended multiple background screening companies in litigation and has served in a variety of chairmanship roles throughout the industry on different groups and boards. He has also been on the other side of the table, if you will, representing companies with their background screening businesses, and he also works regularly to advise organizations on compliance related to the background screening industry. Scott has a storied background beyond that regarding employment law, so he is really someone who is an absolute subject matter expert in this particular area today. We are delighted to have him with us. At Orange Tree, compliance is very important, always has been in the 30 years that we've been in operation. While we certainly pride ourselves on being fast, easy, in terms of providing background screen and service to our clients, that is second to having accuracy in the background report and the work that we do for you, and ensuring that what we provide in terms of deliverable is done right each and every time on your behalf. So without any further ado, it is an absolute great pleasure of mine to turn over today's webinar to Scott Paler. Take it away, Scott.
Thank you, Jeff. Appreciate the nice introduction, and thanks to everyone for taking a few minutes out of your day to join me today. As Jeff suggested, there are very few areas that are changing faster in the employment space than the background screening world. Sometimes I think about, disability cases, discrimination situations, wage issues. Many of them have or really call for advice that is the same in 2019 that we were providing in 2015 and 2010. It hasn't evolved that much. But the background screening area is different. There are a few areas in the employment world that are evolving quicker and requiring companies to think through new practices faster. What we're going to talk about today is how the background screening area is changing, what specific background screening practices and procedures plaintiffs' attorneys are targeting in lawsuits, and what you and other companies that run background checks may want to be thinking about as we're heading into 2020. So the first, how is the legal environment changing in the background screening area? The first thing that you may want to know is that we are continuing to see a significant uptick in background screening lawsuits. It used to be when I began in this area 15 years ago, there were lots of laws on the books, but there were very few lawsuits. Most of the time, employees ran their background checks and never received any scrutiny or criticism related to those checks. That has significantly changed, particularly in the last 5 years. There are now routine lawsuits attacking background screening practices all over the country, and it has proved to be an area that plaintiffs' attorneys like because it often has class action opportunities. And so we expect to see background screening cases continue to grow in number and in popularity in sort of the same way that we saw wage cases growing in number and popularity in the employment space about 15 or 20 years ago. It's kind of a new hot area, and we expect it to remain so. One piece of good news is that as these cases are being filed, there are more and more judicial decisions. And for a while, those judicial decisions seem to be skewing against employers overwhelmingly. We are beginning to see, I'd say, a new trend of at least some favorable decisions coming out of the courts. So I would say if I looked back at the decisions over the last year or two, I think we are seeing much more of a mixed bag in terms of court results than we did in years past, which I think is good. It provides defense attorneys like me new ideas for defending companies that are facing lawsuits, but certainly it's not all positive. It's a mixed bag. As lawsuits continue to increase in this area and as class action lawsuits continue to increase, we are still seeing the growth of very, very large settlements. So it is not unusual in this area at all to see seven-figure settlements come out of background screening cases. That's becoming more and more common. And the reason that's the case is because if a plaintiff's attorney finds an issue, say with an employer's background screening consent forms or their adverse action letters, they're not just making an alleged mistake once, they're making that same alleged mistake over and over and over again over the course of years. So particularly when medium and large size companies are being sued in this area, the settlement numbers, the resolutions in this area tend to be bigger than some people might expect. The other thing I wanted everyone to know on this call is that we are continuing to see an increase in state and local laws that restrict the way in which employers consider criminal history information and credit history information. There is sort of a movement, particularly in blue jurisdictions across the country, to try to make it easier for ex-offenders and individuals with challenging credit histories to get jobs. And those laws not only impose sort of substantive restrictions on employers. For example, they'll say you can't look at crimes that took place more than 7 years ago. Or you have to undertake a balancing inquiry and figure out whether this person really ought to be excluded or not. But they also are imposing certain procedural requirements, so requirements that employers provide new pieces of paper at various points in the background screening process. And we're going to talk about that a little bit today. So overall, we're seeing a significant increase both in the number of cases filed, the number of large settlements, and the laws that are coming up across the country that deal with background screening or background screening related topics. Let's dig in a little bit to the specific background screening components and where we're seeing movement as 2019 comes to a close. So the first area worthy of discussion is the written consent paperwork. As you know, if you're an employer that's running background checks, you can't just do it, right? You have to actually get written consent from applicants or employees before you do so. And the federal law that deals with this area, the Fair Credit Reporting Act, imposes certain requirements. And the biggest consent requirement that's imposed is called the disclosure. And the idea is that a company that wants an applicant or employee to consent to a background check needs to provide a disclosure or a statement to the person that essentially says, we are going to obtain a consumer report or a background screening report about you for employment purposes. That should sound very easy, and for a long time people thought that that requirement was pretty easy. But that disclosure issue has been a hot topic in the litigation. And the reason it's been a hot topic is because the Fair Credit Reporting Act, that federal law, says that that disclosure needs to stand alone. It needs to consist of only itself, and the only other thing that can be included is a simple authorization. And so the plaintiff's attorneys have increasingly made arguments over the last 5 to 10 years to say that if an employer includes unnecessary items in that disclosure statement to applicants or employees, it invalidates the disclosure And it essentially means that the consent process that has been undertaken for the background checks is likewise invalid. It's as if the employer never got consent at all. On the bottom of your screen, you'll see 3 areas that have come up as particular areas of focus in recent lawsuits related to the consent process. And you'll see they all relate to this disclosure requirement. The first, we've seen an uptick in lawsuits and even problematic judicial decisions that say, if the employer is including state law notices in that Fair Credit Reporting Act disclosure, that's somehow a problem. So there are a number of states, California, Washington State, New York, and others, that require that applicants and employees receive certain additional information at the consent stage. And for a long time, what employers did is they sort of combined all of that stuff into the most efficient set of paperwork that they could. And the idea was, let's make it go as smoothly as we can. No need to extend out the consent process. Well, what plaintiffs' attorneys began to say is, wait a second, the Fair Credit Reporting Act is a federal law, and that federal law says that the disclosure needs to stand by itself. It doesn't say that you can throw in the state law notices. So if you're throwing in the state law notices into the federal disclosure, you're doing something wrong. And there was a federal court opinion out of the Ninth Circuit Court of Appeals. So that's a very high-level federal court out by California that said, you're right, plaintiffs' attorneys, that is a problem, and it's a mistake. And so an employee or applicant can get damages if the state law notices are included on the disclosure. So that's one thing to pay attention to. Another thing to pay attention to, it was a long time practice for employers to address both ordinary consumer reports and investigative consumer reports on that disclosure notice. And the difference between those two, disclosures are, ordinary consumer reports are really reports that include things like criminal history, credit history, employment, simple employment verifications, education verifications. Investigative consumer reports are different. They're really interview-based reports. So situations, for example, where the consumer reporting agency goes back to prior employers and does a substantive reference check. Would you hire this person again? Was this person a good performer? Did they struggle with drug tests? What were their biggest problems? What were they good at, right? Those types of interview-based questions. Those types of interview-based questions, when the information is returned to the employer by the background screening company, are called investigative consumer reports. And so for a long time, employers discussed both the ordinary consumer reports, like criminal history checks, and investigative consumer reports in that same disclosure. Although the federal government has said in at various points that that practice may be okay, there's now a new district court decision, again out west where we're seeing a lot of these cases, that found that it is improper for an employer to include a discussion of investigative consumer reports on that FCRA disclosure that talks about ordinary background checks. You combine the two, you have a problem. Right? So one thing that we're encouraging employers to be aware of is that new potential prohibition, and to try to reevaluate the consent paperwork to make sure that we're not including things in the disclosure that might run afoul of the law. A third area that came under attack related to the disclosure, some employers would say something in the disclosure like, just so you know, we're not going to get medical information about you unless we specifically tell you outside of the background screening process. Or we will get medical information about you in the following circumstances. That's another example of something that a plaintiff's attorney accused an employer of following up. That by talking about medical information on the disclosure, they're including a piece that doesn't have to be there, and therefore it invalidates the process. I haven't seen a court opinion yet on that topic in 2019. I think that that might be coming down the pike in the next few years, but just the simple fact that plaintiffs' attorneys are beginning to attack that practice suggests that smart employers should rethink whether that's really appropriate language to include or not. So what are some best practices related to consent paperwork before we move on? I think, number one, let's make sure we don't include the disclosure in the employment application or as part of a larger document. So as soon as you're combining the consent paperwork with other stuff, you're arguably in violation of the Fair Credit Reporting Act standalone requirement. In the middle of your screen, you'll see other examples of statements that have gotten people into trouble, or at least gotten them into lawsuits. Release of liability statements. You know, I, the applicant, release the employer and the background screening company from any and all liability related to running a background check on me. At-will statements. I understand as an applicant that if I am hired, I will be hired as an at-will employee and I may be terminated for any reason. You better be honest statements. You, the applicant, understand that we expect applicants to be honest with us during the application process, and if you are not honest with us during the application process, you may be rejected, or if already hired, terminated. References to the federal notice entitled "A Summary of Your Rights Under the Fair Credit Reporting Act." That's a certain rights statement that the federal government comes out with. It's routine for that right statement to be included with the consent paperwork. But again, that Ninth Circuit Court of Appeals that we talked about just a moment ago said, well, maybe you need to include that as a supplement, but you can't talk about it on the disclosure because the disclosure needs to stand alone. And if you're talking about stuff that you don't need to talk about, you're invalidating the consent paperwork, okay? So where we are overall on this, as you can tell, is that the smart money is on keeping that FCRA disclosure very short and sweet. I can tell you on the versions that we put together for our clients, we are literally down to 4 sentences. And I would not be surprised if in the next year or two, that FCRA disclosure is further reduced to only a sentence or 2. Because all of the lawsuits right now that are coming out are related to the employer allegedly including too much information in the disclosure as opposed to too little. Moving on from consent paperwork to adverse action procedures. This is another area that's under significant scrutiny. So you may be aware that the Fair Credit Reporting Act, the federal law in this area, imposes specific requirements on employers that are thinking about taking adverse action against a job applicant or an employee based on a background screening report from a background screening company. It's not just as simple as, oh, I see something bad in the report, I'm going to reject this applicant. There's a process that's required by Congress. You'll see that it's really a 3-step process. The first step is that employers have to provide a pre-adverse action notice with a copy of the report at issue, and that notice that I just talked about, a summary of your rights under the Fair Credit Reporting Act. It's a governmental notice. Then the second step is to wait a reasonable period of time for the applicant or employee to raise a dispute about the accuracy of that report, right? So maybe they say something like, wait a second, this says that I have a felony. I've never been convicted of a crime whatsoever. Or, yeah, I was convicted of a crime, but it wasn't a felony, it was a misdemeanor. The idea is that Congress wants employers to provide an opportunity for an applicant or employee to identify inaccuracies in the report before any final decision is made by the employer. Typically, employers wait a period of about 5 business days for that review by the applicant or employee to take place, but it can vary a little bit depending on the jurisdiction or the particular circumstances. The third step is, okay, we the employer have waited the reasonable period of time. There's no dispute about the accuracy of the information, so we are going to move forward in excluding this particular individual from the job. There's a very specific letter that has to go out to applicants or employees at that stage that essentially summarizes certain rights under the law. So that's a brief overview of the adverse action process, which hopefully many of you are already aware of. What we're going to dig into now is, well, where is the movement in this area? What are the hot areas for attack? What should we be auditing as we're going into 2020? Well, the first thing relates to matrices that produce automatic results. So imagine a situation in which you, the employer, have essentially a Microsoft Excel spreadsheet, or you have a table that says, if you see, felony murder, automatically exclude this candidate. If you see misdemeanor battery, automatically exclude this candidate. If you see domestic violence, automatically exclude this candidate, whatever it might be. There are new arguments from the plaintiff's bar that say, if you have that sort of automatic matrix that calls for an automatic result, then you're not giving an applicant the right to dispute before you make your final decision, and that's allegedly a violation of the law. There are, believe me, back and forth arguments on that. There are certainly defenses to that. That's not a final decision. You're still going to wait out the dispute period. You're going to go through the letter writing period. If the applicant raises a dispute or the employee raises a dispute, you'll deal with it, and it may be that you don't reject the person. But understand that the plaintiff's bar is looking always for ways to say that something is going wrong, and these automatic black and white matrices are giving them at least some ammunition to do that. The other area that we're seeing a lot of movement on beyond sort of the normal everyday adverse action suit relates to oral comments made by HR or made by the hiring personnel. So situations where, okay, you may have letters that go through the pre-adverse action stuff, that go through the post-adverse action stuff, and those letters are spick and span, they're perfect. But apart from that letter campaign, you have an HR person or hiring person that is calling the applicant and saying, yep, you've been disqualified, right? So they're telling them that the action is final and it's already been taken, right? We have found, as we continue to work with employers in this area and review the lawsuits, that those types of phone calls often create ammunition for a potential plaintiff to say that this letter writing campaign that's contemplated by the Fair Credit Reporting Act is not happening. So increasingly, we are encouraging employers to think about whether they really have to have the supplemental phone call, right? Sometimes they feel like it's necessary in order to have a smooth pre-hire process. I get it. There are various concerns to balance here, but where that sort of phone call is not necessary, it's worth thinking about whether you really want to do it. So let's talk about another area related to adverse action that is seeing a sea change. So a few moments ago, I explained the process that's required by federal law, by the Fair Credit Reporting Act. But in recent years, a number of states and municipalities have said that employers can't just satisfy the Fair Credit Reporting Act requirements for adverse action. They also have to satisfy certain additional requirements under state and municipal law. For example, the New York City has this very specific form that employers need to go through that assesses a variety of factors in the criminal history context when they're considering disqualifying someone based on a criminal conviction. Los Angeles has something similar and requires certain information to be conveyed both at the pre-adverse action stage and at the post-adverse action stage. There's a brand new one just out of Columbia, South Carolina very recently, making clear that certain additional information has to be provided in the criminal history context when an individual is being excluded based on a past offense, okay? What you see on your screen are certainly not all of those state and municipal laws. By my count, there are something like 20 to 25 different jurisdictions that have meaningful additional requirements at the adverse action stage under either state or municipal law. And the hard part too is that just as you see right here with Columbia, South Carolina passing a new law a few months ago in 2019, there are going to be additional jurisdictions that pass those laws as well. And so for employers that have a multi-state presence, it's going to continue to be harder and harder to try to tackle these state and municipal requirements. The days of yesteryear where you have a one-size-fits-all adverse action letter that can be used across the country and it's only one page long, those days are really over, at least for large employers with a multi-state presence. So what are some best practices for adverse action letters? Well, the first thing is really to make sure that you're providing both the pre-adverse action letter and the post-adverse action letter. That still remains the #1 problem that gets companies sued. They're either not sending either letter or they're only sending one or the other. In the employment context, we need to send both. Second thing to be aware of, the content of those adverse action letters matters. It's worth taking a look at the wording. And if the pre-adverse action letter says, you the applicant, or you the applicant have been disqualified, you the applicant are not getting this job, keep in mind that at that pre-adverse action stage, it's really only supposed to be a consideration. It's not supposed to be a final decision. And wording to the contrary invites a lawsuit, and it's often a class action lawsuit. Third thing, as I mentioned on a prior slide, be aware of those verbal comments, right? And if it's really necessary to have those supplemental phone calls with job applicants, then it's worth thinking through how to train either the HR personnel or the hiring personnel to make sure that they don't say the wrong thing during those phone calls. And the last thing is to make some effort, if you have a multi-state presence, to be aware of and comply with these state and municipal law requirements, right? And I think there's really two ways to think about doing that. One is to do a little research every time you have an applicant from a state that you're not familiar with, right? So if you're based in Minnesota, but you have a new applicant this time out of California, and that's unusual for you, and you're thinking about excluding them, make sure you're aware of California's limitations. Or alternatively, work with counsel or work with HR consultants that really have a handle on this area and can help you to set up a systematic process that tries to account for all of these varying laws from state to state. So far, we've talked about really procedural requirements. We've talked about written consent requirements and how that's evolving. We've talked about adverse action requirements and how that's evolving and what plaintiffs' attorneys are going after. Where I want to turn next is more to substance, right? So, okay, you get a background screening report that has criminal history information. That's the most common issue. What do we do with it? What do we have to be aware of? Where are we now, okay? The EEOC in 2012, the Equal Employment Opportunity Commission, really got the train started to say that employers have to be more nuanced in the way that they analyze criminal history information, and they can't just exclude everyone. And the idea is that the EEOC at least believed that employers were excluding too many individuals based on their criminal history, and that that was working to the disadvantage of certain minority groups. And so they began to make it a priority for the agency to investigate and bring lawsuits related to background screening practices. That's no longer new. That really dates back to 2012. And what the EEOC said, as you see on your screen, is employers should really make a job relatedness assessment and also think about how long the crime occurred, how long ago the crime occurred, and if it really does appear to be job related, then to do an additional individualized assessment in which the employer looks at how the individual has grown and matured since the time of the crime. So ask them questions about what additional education they've gotten, what additional training they've gotten, whether they've been bonded, whether they've worked in a similar job, things like that that will help the employer to make a more nuanced analysis of whether someone really ought to be excluded based on their criminal history. Well, the EEOC sort of kicked off a new movement that has taken over, particularly in blue jurisdictions, both at the state level and at the municipal level, that have essentially codified into law in those jurisdictions that same criminal history philosophy that the EEOC advocated for in its 2012 guidance. The biggest states that we've seen movement on, California and New York are big ones in particular. Massachusetts, we've seen some movement. Wisconsin does have a law, that's where I'm based, but that law is a little bit more dated. Pennsylvania has a law related to substantial relatedness and whether a crime has to be connected to the job or not as well. And then we'll see cities like Seattle and San Francisco pass laws. So on a big picture level, it's important to be aware that although there is not a federal law that says employers cannot consider criminal history information, there is EEOC guidance that says employers have to be more careful, and there are states and municipalities that are imposing more specific restrictions on the criminal history information that employers can use, okay? By and large, those state and municipal requirements have come to pass in really the last 5 years. That's when we've seen the biggest growth in this area. But in terms of 2019, where did we see the biggest growth? It's really in relation to administrative claims or lawsuits related to these state and municipal requirements, which are often called Fair Chance Act requirements or ban the box requirements. So really what we're beginning to see now are the first wave of enforcement efforts. It's like, okay, California, New York, Massachusetts, DC, they have these restrictions now, and now either the government agency that oversees that area or private plaintiffs' attorneys are bringing actions to enforce those new laws that have been passed in the last 5 years. I frequently get questions from employers, particularly that have a multi-state presence, about how significant these Fair Chance Act and Ban the Box laws are, because many of them feel that they're burdensome and they're difficult to keep track of. What I said before 2019 is that those laws are out there, but we're not seeing a lot of action. What I would say now at the end of 2019 is those laws are out there and we're beginning to see action. And the areas where we're beginning to see the action the most, New York, Massachusetts, and DC. So what are some steps that an employer like you can take to try to limit risk related to the use of criminal history information? What you see on your screen are a number of different suggestions that we tend to make to employers to help them try to avoid as much risk in this area. The first is sort of obvious. You know, the days of yesteryear in which employers had no felons allowed policies or no convicts allowed policies, you know, in today's day and age, that's tougher to support, right? Employers that have a small presence and that are located in the South may have some ability to get away with that type of practice today. But for employers that are certainly on either coast or that have more of a presence in the North, that sort of no felons allowed, no convicts allowed policy is a liability. Second thing to be aware of, you know, most employers still do not have much in the way of written policies on background screening. It seems like whenever I review employment handbooks, they now have a policy on practically everything, or an operations manual, practically everything. But one area we still see very little traction in relates to background screening. We're not seeing written policies on background screening. And we think it's important for employers to reconsider that, right? Because if lawsuits are popping up more and more in this area and the numbers are very high, it's incumbent upon us in the employer community to make sure that we have policies that are, number one, well thought out to try to avoid those lawsuits, but number two, hopefully also policies that suggest that to whatever extent we make a mistake, it's a bad apple mistake and it's not a systemic mistake. So those sorts of written policies can help keep punitive damages down or other type of multiplier damages down. And they don't have to be super long. A lot of times when I work with employers on those policies, you know, they're only a page and a half, 2 pages, and even that can have some appeal. Third thing is that, you know, in general, employers are focusing more and more on criminal convictions and less on charges that resulted in dismissal or acquittal. And we think that that is a good idea. Fourth thing, most employers are now, and we do encourage this, making some effort to consider substantial relatedness. That's particularly, and on criminal history, I should mention. That's particularly important in states like California, New York, Wisconsin, Pennsylvania, that have laws that require substantial relatedness assessments and that routinely have administrative claims or lawsuits attacking employers for not having that job relatedness. But even outside of some of the big states that I just mentioned, a lot of times it does make sense, even from a business perspective, to do that job relatedness assessment, because frankly, some criminal convictions mean more than others, right? And some it's worth moving ahead with the candidates, and some it's probably a good idea not to. But kind of the days of yesteryear again, in which it's a no felons allowed policy, is probably not the most well thought out approach today. It's worth considering doing an individualized assessment along the lines of what the EEOC recommends, and now California and some other jurisdictions effectively require. That individualized assessment, again, is geared towards figuring out if the applicant has grown and developed and matured since the time of the crime, such that they present less risk when you look into it than they otherwise might seem based on the face of the report. And a lot of times employers can accomplish that individualized assessment either through a written questionnaire or through a very short interview with the candidate. And that also has some advantages, particularly for employers that are routinely dealing with the EEOC, because the EEOC really looks for that sort of process. We talked a little bit earlier about how matrices are under attack And they're under attack not only in the procedural space, but they're also under attack on the substantive space. Because when employers are saying an if this, then that automatic result, it essentially means that the employer is not doing as much of a nuanced inquiry or a case-by-case assessment or an individualized assessment to see if the person really ought to be excluded or not. So when we work with employers that favor some sort of matrix or more rigid process in order to achieve consistency or in order to achieve a smooth pre-hire process, we're encouraging them to be thoughtful about the language used and to potentially step away from automatic results and lean more towards likely results. And the last thing, as you see on your screen, and you've heard it from me several times today, the states and municipalities, particularly in blue places, are passing more and more laws that restrict the type of criminal history information that employers can use and also prescribe when they can use that information. And so it's really important to either have a resource that helps to keep you on top of what those state and municipal laws might be, or to work with attorneys that are knowledgeable about this area and can advise you on those state and municipal requirements. Credit usage is another topic that's worthy of thinking about today because it's another rapidly evolving topic. The EEOC has come out really against the use of credit reports by employers on the basis that just because someone has delinquencies in their credit file, just because they haven't paid on time always, doesn't mean that that indicates that they're going to be a worse employee. And they've also come out against it because they believe that the use of credit reports by employers is having a disproportionately negative impact on certain minority applicants. So the EEOC is out there against it. And just as we talked about in the criminal history space, that states and municipalities in blue jurisdictions are sort of jumping on that EEOC bandwagon, we're seeing the same darn thing in the credit space. So approximately 10 states in the last, I'd say 5, 7, 8 years have passed laws that either restrict employers from using credit history information or limit them to certain circumstances or require certain additional paperwork if the employer is going to do a credit check. Likewise, we're seeing cities in blue areas jump on this bandwagon. New York and DC are the first two that come to mind that have passed laws in the last handful of years that again restrict when employers can use credit history information and the process that they need to go through. But it's important to keep in mind that this area too is rapidly evolving. Just very recently, Puerto Rico instituted a new restriction on the ability of employers to use credit history information. They have made it very hard for employers to use credit history information except in narrow circumstances and then require additional paperwork to be conveyed to applicants in those narrow circumstances in which it may be allowed. What I tend to tell employers that I work with that are considering credit checks is to really limit the number of credit checks that they're doing, to think about when they make sense and when they don't. I would say for the most part, they can make sense for accounts payable type positions or CFO type positions or things like that. Outside of those types of payment type positions, they tend to make less sense. Also, to be aware of the state and municipal laws. If you're going to run credit checks, it's important to be aware of how these states and municipalities restrict their usage or what type of paperwork that they require. So the last topic we wanted to talk about for today before we get to your questions is insurance, right? So you've heard me say on several occasions today that the number of lawsuits is increasing, that the amount of damages or settlement payments that come out of these lawsuits are increasing, the number of laws that restrict what employers can do are increasing. So it's more of a minefield today than it was before, and it's more of a minefield at the end of 2019 than it was at the beginning. So one thing that employers are beginning to think through is insurance, right? Because at least a decent number or decent percentage of employers do have EPLI insurance, so insurance for employment practices violations, which I think can be a useful asset and is certainly something that's worth thinking through. But one thing I always try to bring to the attention of employer clients is the idea that just because you have an EPLI policy does not mean that it's necessarily going to cover anything and everything related to employment, right? An insurance policy only covers what it says it's going to cover, and it routinely has exclusions that will carve out certain types of claims. It's not unusual to see EPLI policies carve out background screening claims. And the biggest reason is because insurance companies are not dummies. They know that this is an area that is seeing an uptick in lawsuits and an uptick in big damages and big settlements. And from their perspective, they don't want to have much to do with it, right? So if you are an employer that has EPLI coverage, but you want to make sure that your EPLI coverage will protect you in the event that you suffer a background screening claim, what you see on your screen are examples of exclusions to be particularly aware of, right? So if the background screen, or if the EPLI policy says it doesn't cover FCRA claims or consumer protection claims, privacy claims, claims that allege recklessness or willfulness, or my personal favorite, claims that arise under federal or state statutes. If any of those things are present, you're probably unlikely to have coverage for background screening claims under the EPLI policy. So if that's something that's meaningful to you, think about looking at alternative policies. Also think about the maximum coverage number, right? So it's not unusual for the policy to say something like, we're only going to cover claims up to a maximum of $50,000 or $100,000 or $75,000 or $500,000 or whatever the case may be. Keep in mind that background screening settlements and background screening resolutions, particularly in class actions, are often exceeding that figure, right? We're seeing 7-figure settlements. We're seeing high 6-figure settlements. Occasionally, we're seeing 8-figure settlements. And so keep in mind that if you're relying on the EPLI policy to provide you protection in the event of a mistake, that maximum coverage number matters. Likewise, the deductible matters, right? Because the deductible indicates to us when that insurance coverage kicks in. So if you have a really high deductible, it very well might mean that you're not going to have single plaintiff lawsuit protection because the numbers aren't going to kick in until it's sort of too late. So we've talked about a number of different areas today, from the procedural requirements under background screening laws to the substantive evaluation of background screening information, how plaintiffs' attorneys are finding weaknesses, what they're looking for, and also what you as an employer can do to audit your current practices to try to make effort to limit risk. We have, I think, about 15 minutes or so left in today's session. So I would love to hear what questions you might have, and I'm happy to provide any additional insights you think might be helpful. Thank you so far.
Scott, thank you very much for the presentation. What a collection of topics to talk about. So as Scott did mention, we do have time here for some questions. Our first question is from Shauna, which is, what is considered extraneous information?
Yeah. So this question goes back to one of our early topics, which is what sort of extraneous information is going to make the disclosure invalid, right? And the unfortunate reality for that question is that's yet to be determined, right? What is extraneous and what is not? I would say that at the most basic level, what we know has to be included in the disclosure is a statement that the employer is obtaining a consumer report for employment purposes, right? At the most basic level, that's what is required. The question is how much additional information to put in beyond that. So are you going to define consumer reports? Are you going to talk about the types of information that's going to be included in consumer reports? Are you going to talk about certain other definitions of consumer reports? In general, we think many of those things ought to still be included in the disclosure. But there are other things that don't need to be included, and I've included probably a half dozen examples of those things that likely don't need to be included during today's presentation. At the end of the day, it's worth working with counsel, showing them the disclosure and authorization paperwork that you have, and thinking through every single word in the disclosure. Does it need to be there? Does it not need to be there? And if the answer is it doesn't need to be there, then it's certainly a consideration to remove it, because most of the lawsuits, as we talked about, are focused on including too much information.
Scott, another question. Do you think companies face greater risk if they're headquartered in one state versus another? And if so, which states might present the greatest concerns?
Yeah, that's a really good question too. I would say that certainly there are certain jurisdictions that are seeing more background screening claims than others. And the ones that immediately jump to mind, California is undoubtedly number one. New York is probably undoubtedly number two. And then after that, it's some combination of probably Wisconsin and Pennsylvania that sort of fit in next. But in general, for employers that are located in blue jurisdictions, they inherently have more risk in this area, because there are more laws and there are more plaintiffs' attorneys that are looking to leverage those laws.
Scott, you mentioned that we should audit our EPLI insurance policy. Aren't these insurance policies standard? In other words, even if we saw a type of claim excluded, it is what it is, right?
That's a really good question too. You know, I would say that there's sort of a misconception that insurance policies are non-negotiable. And in my experience, that is 100% not true. Insurance companies will negotiate policies when it makes sense to them from a business perspective. And I've had a lot of negotiations with insurance companies to try to improve the quality of the policies that my clients have. You know, I would say sometimes you're able to get movement and sometimes you're not, and it depends on the insurance company. But I wouldn't assume that there is one standard version. There is not one standard version EPLI policy, and they vary from underwriter to underwriter, and they, in general, can be negotiated.
Okay, very good. Scott, there was a question, what are blue jurisdictions?
Oh, sorry. I've used that phrase a lot, so hopefully too many people aren't raising eyebrows when I say that. Blue jurisdiction, I'm referring really to blue in the political sense, right? So there are certain states that tend to vote more on the Democratic side or more on the left side. So we know that the coasts, for example, the West Coast and the East Coast tend to skew more Democratic or more blue. Likewise, in the central region, Illinois tends to skew more blue. Sometimes Minnesota does as well, right? Wisconsin, where I am, is sort of more mixed. The states that tend to vote more democratically tend to have more laws in place that are designed to protect individuals that have a prior criminal record or that have a checkered credit history. And likewise, states that lean more blue or tend to vote more democratically tend to also have a more active plaintiff's bar.
You know, having said that, Scott, I mean, the organizations we're working with, and I'm sure you work with too, are receiving, they have locations in many of those states across the board, the different colors as you mentioned it or describe it that way. What sort of approach do we take? Is it a one size fits all sort of approach, business policy, hiring policy, disclosure application, you know, et cetera and so on? Or is this something that really has to be customized by region, by state? I mean, can you provide some guidance there maybe?
Yeah, and I would say it's hard. I mean, for employers that have a large presence in a variety of different states, they sort of have a decision to make. You know, do you abide by the highest standard in any one of those cases, but then have the advantage of a standard process? Or do you sort of differentiate office by office, state by state, abide by the more stringent standards where it's required under state or municipal law, and have more leniency and flexibility when it's not required by state and municipal law? I think that's sort of a business decision. I would say when I work with employers that have a presence in a variety of different states, that's a question that we often talk about. It's one that I'm planning to have a discussion with the client about tomorrow, because they're facing exactly this conundrum. And so I'd say I have employers that land on both sides of that fence. Some prefer a very standard process and are willing to abide by a more stringent standard across the board. Others want flexibility that certain state laws may allow them to have. So I think it really depends.
Scott, we have a question from someone from a representative an education institution, university likely. The question is, some of my students are more worried about employers viewing their social media sites. Have you seen an uptick in lawsuits when employers view information from a candidate's social media post?
Yeah, that's a good question.
Or post. Mm-hmm.
I would say we have not yet much seen in the way of lawsuits. Still, the social media checks that employers are doing, sometimes with the help of background screening companies and sometimes on their own, are sort of in their infancy. I would say everyone's still kind of sorting out, when do we want to do that? Who do we want to have do that? What information should we look at? What shouldn't? Should we filter information? Should we not? I would say the kind of the good news for employers is that the plaintiff's bar hasn't really focused on this area yet. So I think there is still time for the moment for employers to think through what makes sense and to try to manage the risk in that area. Do I expect lawsuits to be coming down the pike? For sure, because I expect social media checks to be more and more popular in the employer community, and given the focus and scrutiny on background screening by the plaintiff's bar, it seems like it's only a matter of time until they start focusing on that hot topic.
Scott, maybe just a follow-up question I have to that. Someone who oversees the industry, et cetera, and so on, what might, if anything, on this call, could you offer for this individual who is working with these individuals are very desirous to know what are best practices? What are things I can do to have a social media site that is representative of who I am today as I'm entering the job market, as opposed to maybe who I was when I was 16, 17 and not quite aware of what I said, how I said, what I forwarded. And now, gosh, that's 6, 7 years later. I didn't understand that data lived forever. Now I do.
Yep.
Any sort of counsel you could provide?
I would say, in general, as everyone on this call knows, I mean, information on the internet sort of never totally goes away. I would say if I were, talking to applicants about this issue, obviously the greatest step any of them can take is to try to avoid publishing controversial or unsavory things on their social media accounts, knowing that it might surface someday in a way that they don't want. But putting that aside for a moment, because we all know that that's not entirely realistic, I think, the next step that applicants can take or students can take is at least to scrub their social media accounts as best they can before they apply. Because for the most part, employers or background screening companies that are working with employers are likely only to see the surface level detail in social media accounts. And so if someone has effectively erased a really bad Facebook post or Instagram post or whatever, it's certainly not as likely to show up as if it's still there, right? It should show up in a report as if it's still on the social media account. So I think that's the second best alternative.
Do you have maybe I hope this doesn't put you on the spot or in some sort of awkward position, but you do have expertise on the employee side, employer side, I should say, for sure. You're an employer. The temptation, of course, is great to look at all these different social media sites, and we're all human. We all have. You mentioned something earlier about blue jurisdictions and I suppose red jurisdictions, if you will, or parts of the country. So there's points of view, and you have these terms like toxicity and whatnot. And I guess I'll just offer, for the sake of my question, there could be a lot of subjectivity into what does toxic mean.
Yeah.
So do you have counsel, guidance to employers who are tempted, if not need to go to the Google prompt and look at sites and make decisions and protect their workforce? How do you do that in 2019, 2020?
Yeah, I mean, it's a really good question, Jeff, and one that I think all of us are sort of sorting out, I would say where we are right now, what we know for sure is that we don't want employers to be factoring in protected class information, right? So one of the challenges with social media accounts is they might show that someone has cancer or MS, or that someone is gay or a religious minority, or whatever the case may be, right? Social media often shows sort of details about someone that an employer, when they're making a decision in the employment context, would sort of just assume not know, because they don't want to be accused of making a decision on an improper basis, right? So one thing that we know for sure, and we counsel employers to do, is to set up a process, whether on their own or with the help of a background screening company, that's designed to make sure that whoever the decision maker is does not receive quote unquote off-limit stuff, does not receive protected characteristic, protected class information stuff. So that's, you know, sort of rule or conventional or best practice wisdom number one. Then if you, assuming you filter out all of that stuff, then you're sort of left with a remaining pool of social media information that isn't necessarily legally problematic, but then you're trying to decide, should we factor it in business-wise or not? And on that question, I have employers that vary substantially, right? So I have some employers that will, you know, look for things like, they'll look for curse words. They will look for postings of nudity. They will look for derogatory comments about minorities. They will look for suggestions that the person is lazy, not showing up for work, criticizing a prior employer, right? All the types of things that an employer might be looking for if they were doing a reference check or if they were doing pre-hire interviews, sort of bringing the same mentality to a review of social media information. The one thing I would end with on that, Jeff, too, is that there are a number of states that now have laws that say employers can't require applicants or employees to share their social media password, right? So in general, employers are only permitted to view and access what is publicly available. They're not allowed, as a general rule, to require applicants to allow them a pass behind the curtain.
What about states without such laws?
Yeah, well, in states without such laws, theoretically you could. I would say, though, that that movement has sort of circulated around the country, and I believe several dozen states now have that sort of limitation.
My sense is, Scott, we could continue a Q&A here for quite a while. However, we are at 1 o'clock. I am very appreciative of all of the great content, especially here the last few minutes, the Q&A. So thank you very much. For those of you that have questions, there is a thank you also, Scott, for cleaning up the screen here. We had a snafu with our chart. So we do have some contact information available to you. You can reach out to me, Jeff Ernst, at Orange Tree. You see a phone number there as well as an email. And thank you very much for your attendance. We'll send out an email following up. So if you want to listen to this again, send it to colleagues, you will be able to do so. Thank you again, Scott, for the terrific counsel and webinar this afternoon. Thank you, everyone. Have a wonderful day and wonderful holiday season.